It is sort of, it fits within the discussion that we've already had. The idea here is the legislature did not want people just kicked out on the streets if they were subject to a judgment after a civil lawsuit. The idea being that you don't want to just have an army of people that have nothing other than the clothes on their backs roaming the streets because they've been displaced from their houses because they lost a civil action. So the idea then is that you have a protection. Now, it's not just on the house. There are other exemption categories. Your household goods and furnishings are exempted without dollar limit. That includes your clothes. So you're not going to be stripped bare and put out on the streets, even though that might, for some, sound entertaining. The idea instead is that you're supposed to be left with something to get started again. The creditor can still, of course, record a judgment lien against the property, but the homestead exemption is designed to protect the house so that you have a place in which to live. Now, if you have a great deal of equity in the property beyond the homestead exemption, well, a creditor could conceivably initiate a foreclosure sale, a judicial foreclosure sale, and get the house sold so it gets paid. Now, of course, you get your exemption. Although there is a hierarchy, some types of debts sometimes step in front of your exemption. Property taxes, for example, will step in front of your exemption, certain other taxes. But the idea behind this is that it's supposed to protect you so that you don't lose your place of residence. Now, what's interesting is if the property is sold, and this sometimes comes up in a bankruptcy case where, say, a Chapter 7 trustee seizes a house that has some non-exempt equity, there's too much equity to completely protect, then the trustee will sell the property, pay the cost of selling the property, write you a check for your exemption amount, and then use the proceeds to pay creditors and take a cut for the trustee's services. You have 6 months in which to reinvest that money that you got from the trustee, and it's measured from the day you receive the money. So for that 6-month period, that money is exempt as your homestead. Now, you're not going to make a little house out of piles of dollar bills, but that is your homestead. But if you do not reinvest it within 6 months, then it loses its exempt character, and the trustee can come after you and demand that you disgorge that money, and will use that money to pay creditors. And similarly, outside of bankruptcy, if there is an involuntary sale, well, you're supposed to get your homestead, but you have to reinvest it again within that 6-month window. And if you don't, then it loses its exempt character as your homestead. One of the benefits of having the homestead bumped up to $600,000 is if you have a house that has more than $600,000, well, with $600,000, you can probably get a place in which to live. It won't be some palace in Beverly Hills, but at least you'll be able to get a pretty decent place. This was not the case before January 1st. Under the old system, the very maximum you could possibly get if you were either over 65 or disabled, or over 55 with household income of less than $25,000 a year, was $175,000. Well, in some parts of the country, you can just buy a house outright for $175,000. That's not the case in Southern California. And so if you've just come out of bankruptcy, your credit for getting a home loan, your credit score will probably increase as a result of the bankruptcy, but your ability to get a home loan will not be there for a couple of years. And so with $175,000 as a down payment, well, creditors are willing to lend money if you've got some skin in the game, but that's not enough to really get going in Southern California. And so that's where we have a little bit of a problem that was solved on January 1st when the homestead went up to $600,000.